Welcome back to Let's Talk Employment Law, a video podcast brought to you by the employment team at Neave. Please remember the information contained in this podcast is not intended as legal advice. It is not a comprehensive statement of the law. It is just a general discussion, and hopefully it spurs some thoughts and questions for you. My name is Hannah Martin and I'm a Senior Associate in the employment team based in Christchurch, and I'm joined today by Elise Wilson, who is a solicitor in the team. In the past 3 episodes, we've been taking a look at the legal requirements of the Parental Leave and Employment Protection Act and the practical application of it in New Zealand. So we've looked at the different types of leave and the terminology used in the Act, and we've looked at the obligations on employers and employees leading up to the taking of parental leave and while an employee is on parental leave. In this final episode, we're going to discuss the ins and outs of employees returning to work after their period of parental leave has ceased.
Thanks for that, Hannah. And like Hannah said, there are some obligations on employers and employees when they are returning back from their parental leave period. And so the first is around notice requirements. The Act does require at a minimum that 21 days notice is given of an employee's decision to either return back to work or not to return to work. And if an employee does decide after their parental leave period not to return, then their employment is deemed to have ended on the date that they began their parental leave. And another point to be aware of is that in addition to employees accruing leave while they are on parental leave, such annual leave payments will be made at a lower rate. This is due to the calculation of annual leave while employees are on their parental leave period.
Yeah, so it's beneficial for an employee if they use their annual leave entitlement prior to going on parental leave. It is paid out at a higher rate, and based on how annual leave is calculated in the Holidays Act anyway. So it's just something to be aware of. It's a pretty nasty surprise for some employees if they decide not to return to work because they're loving parental leave so much, but they've found out that any annual leave that they have was actually now worth less than it was when they went on leave. There is a presumption that an employee's role will be held open for them on their return from parental leave. This is the case unless it's not reasonably practicable for the employer to find a temp because that employee holds a key position, or, as we discussed in the last episode, that position has become redundant. So these are relatively high thresholds to meet for an employer, but if either aspect can be proven, then the employee does get a 6 months preference of re-employment, which means that for the following 6 months after their parental leave ends, they have preference over any other job applicant for a job that is substantially similar to the one they held prior to going on parental leave.
Great, thanks for that, Hannah. And upon returning from work, some employees may request flexible working arrangements due to their new commitments. And so under the Employment Relations Act, all employees are entitled to request flexible working arrangements from their employers. So this could include changes to the times that they work their guaranteed hours of work, the location, or maybe they will start earlier and finish later, options such as that. So the Employment Relations Act does provide a framework for employees to make these requests, and also provides that employers need to respond to these requests as soon as they can. And the Act does set out some reasonable grounds for such a request to be refused, but we do recommend that if you're not sure about how to respond to such a request, you do seek further advice. And this is quite an important point because not only are flexible working arrangements being requested by employees returning from parental leave. Also now, due to the COVID-19 situation, a lot of people generally have realised that they can perform their work flexibly. And so we do recommend that employers consider their approach to flexible working and also consider their obligations here under the Act.
Speaking of COVID-19, it is worth noting that a temporary change has come about in relation to primary care leave. So As a result of this change, people on primary care leave can now return to work for a period of up to 12 weeks and not have their parental leave payments affected if they are in a position that is in unusually high demand at the moment, or they have the skills, qualification, experience, which means that the employer couldn't find a replacement for them, but because of COVID they need to have someone in that role, then that person can go back to work for up to 12 weeks. This goes against the general rule, which is that in the first 26 weeks you can only do up to 64 hours of work using your keeping in touch days, and that usually the 26-week period needs to be taken continuously. But if you're one of those special people that this exception applies to, then you can go to work for up to 12 weeks and then come back on primary care leave and use the rest of that leave period which you haven't used up yet.
Cool, thanks for that, Hannah. And another requirement to be aware of is that employers are under a legal obligation in the Employment Relations Act to provide adequate breastfeeding facilities for employees who are returning back to work. So this requirement means that there must be both adequate place for the employee to breastfeed and also adequate breaks provided for this. And it's also important to note that it's not only for breastfeeding but also for expressing that these adequate facilities must be provided. And these breaks for breastfeeding or expressing are on top of an employee's minimum entitlements to breaks in the Act. So it's important to make sure that you are prepared for the employees coming back to not only have the place so they can breastfeed but also have the time available to them to be able to do this. And lastly, the obligation of good faith is something that is crucial to any employment relationship, but especially when employees are returning back to work from parental leave, we recommend maintaining this good faith, and this might mean having more conversations with them about any requirements that they need to do their job, or it might be responding to their flexible working requirements and requests constructively. So we do recommend that you get any advice if you have any issues around this return back to work, but that you do work to your best ability to maintain this relationship as constructively and positively as possible.
Yeah, thanks, Elise. That's a good point. It certainly makes for a more productive and positive employment relationship. So what we hope that you've taken away from these 4 podcasts in this series is that there are some legal requirements and minimum entitlements which employees and employers must adhere to in relation to the taking of parental leave. There is, in addition, some things that employers can provide over and above those minimum entitlements which don't necessarily cost them any money, but if implemented in terms of in the form of a policy, would bring them up to more closely aligned with current social standards and expectations. But again, all employers have different resources. What's important is keeping an open, honest and productive employment relationship and adhering to those minimum entitlements. So thanks for joining us on this final episode of this 4-series podcast, and we hope you've enjoyed it, and if you have any questions, please do not hesitate to get in touch.